Hello, everyone who have already joined. So today it's a webinar from Zen EB-5. My name is Bhuplesh Gupta. I'm the Vice President at Zen EB-5. We have Reema Rasool. She's our Manager of Investor Relationship. And we have a special guest today, Kripa Upadhyay. She's an attorney at Buchalter. Is that how you pronounce?
Buchalter.
Yeah, all right.
It's Buchalter.
Buchalter. All right. She's a very well experienced EB-5 attorney and general immigration attorney in Seattle. So she'll be talking a lot about 2025 and what's going on in 2026, the grandfathering, the program in general. And we'll keep it very open conversation. So if you have any questions, keep on posting on the Q&A section and we'll be taking in between.
So thank you
Please.
so much, everybody, for being here tonight. I know it's a Monday evening. I know it's a weird holiday week. I just want to start by saying that it is a real pleasure to introduce our guest speaker this evening. Kripa is a highly respected attorney at Buchalter who specializes in complex U.S. immigration strategy. And I'm extremely grateful that she's given us her time tonight. And I just want to start by saying that this webinar is completely educational. Kripa is in no way connected to Zen EB-5. And she's here as our guest just to answer questions. And we're so grateful for your time, Kripa. Thank you so much. And we're looking forward to your presentation. Thank you.
Thank you. Thank you, Reema, and thank you, Bhuplesh. So like Reema said, I am an independent, if you will, attorney. I am based in Seattle. I am the co-chair of the Immigration and Global Mobility practice for Buchalter. Buchalter is a national firm. We are at about 500 attorneys now, 500 plus attorneys now, and I am the incoming chair of the immigration practice. I've been in EB-5 land, as I call it, since 2010 at least. I also serve on the American Immigration Lawyers Association's National EB-5 Committee, which is comprised of immigration attorneys primarily in the US that have high volume practice and a lot of experience with EB-5. So this slide does, and I have one at the end as well with my email and my phone number in case you all have any follow-up questions. Feel free to get in touch with me, and I would recommend that you please get in touch with me through Reema and through the regional center. But the comments for at least for this session are going to be largely focused on what's coming up. Where we are right now with the program, I will talk a little about adjudication trends, but really more about what's coming up in 2026 and 2027, because these are both very crucial years, significant changes afoot for the EB-5 program. So I will spend more time, not more so on an overview of the program. And again, feel free to send questions if you have questions about more introductory aspects of the program, but I'm going to spend more time talking about what's coming up. So overview for those of you that may be very new to EB-5, the overview is that we are currently working under what is called the Reform and Integrity Act of 2022, or the RIA. The prior version of EB-5 ended in 2018. And so the new version that we have is the Reform and Integrity Act of 2022, or the RIA. It started in March 15, 2022. The significant difference under the RIA is that the amount has increased from what used to be 500,000 to now 800,000 for regional centers, or for your own investment, right? So traditionally, the EB-5 regional center model is what we call the pilot program. That part of the program is generally authorized every 5 years. So that part, the pilot program, is subject to sunset dates or end dates. But the EB-5 program as a whole is codified into law. And so that never expires, right? The EB-5, general EB-5, if you will, is the self-directed EB-5, which is where you do your own project. And currently, if you are in a rural set-aside or a high unemployment or an infrastructure project, then technically you can do that for 800,000. If you want to do your own investment outside of those areas, then that is 1.5 million. All right. So what the RIA brought about is significant changes with respect to the amount of money that is required, which is now a minimum of 800,000 for a regional center or via a regional center. And we now, for the first time since the history of the EB-5 program, have specific reserved quotas for investors that are investing in rural or high unemployment or infrastructure, right? So currently there is a 20% set aside for rural, 10% set aside for high unemployment, and a 2% set aside for infrastructure. There is no definition yet for what an infrastructure project is, which is why you won't find more than maybe 2 projects in the market right now that are infrastructure based, just because there isn't a lot of history of an infrastructure project. The rural projects and the high unemployment projects tend to be historically more common within the EB-5 landscape, and they have various degrees of, returns and return on investments and lock-in rates, and so that's going to differ project to project. But again, this is like I said, where we are. 800,000 minimum if you are in a rural high unemployment or infrastructure, 1.05 for everything else. Total cost for a rural TEA probably closer to 920 right now. I have said 950, and that's to account for the administrative fees, which depend on each regional center. The highest I know of is 90,000. Is rather obscene after they're charging you 800,000, but what do I know? Attorney fees are between 20 and 35,000, depending on the expertise of the attorney. Those of you that are filing now are luckier than some of your friends that may have filed earlier in the year, because the filing fee has significantly dropped from 12,160 down to 3,675. And again, one of the things that works really well, and I'll probably get some questions later, is the role of mandamus in EB-5 land. It is very, very popular. And one of the reasons that this came down was because there was a lawsuit filed by AILA and by some attorneys that are part of AILA challenging the significant increase without a proper study, right? So anytime USCIS wants to increase the fees, they are required to do a study, an impact study, and then actually publish that route and justify why the fees were increased. The service didn't do that this time around, and so we were able to get them to reduce it because they didn't want to lose in court. So those of you that didn't file earlier in the year have the benefit of now filing for a significantly lower amount of money than you would have been paying otherwise. The I-526E, which is your EB-5V, your regional center application, and even the general generic EB-5, if you will, or the traditional EB-5, that 800,000 covers you, your spouse, unmarried children under the age of 21. So generally, the adjustment of status fees that you see here, that is per applicant, but the rest of it generally covers the entire family unit. All right. Rural, so as of now, and I'm basing this also based on the January visa bulletin, which was released, I think, 2 weeks ago. But as of now, there is no backlog that is reflected in the visa bulletin. And so if you are filing in a HUA project, which is what this is, the Zen EB-5 is an HUA project, you should expect a filing processing timeline of somewhere between 10 to 16 months. I think 24 months is a little on the outer limit now, right? That is, so these timelines are where we used to be, I'm going to say until about August of this year, but there's been a marked shift at IPO where they seem to be working quicker on some of these cases. I'm starting to see my rural cases take about 8 months, start to finish, for a decision. HUAs were at 16. They're probably down to about 10 to 12 months now. So that it seems to be comparable between HUA and rural, right? There's not a whole lot of difference. There was a significant difference earlier in the year, like I said, until maybe about August. Direct is a lot harder to estimate, and I also don't want to talk about direct right now. If you're interested in direct, I'm happy to walk you through it. But the direct is a whole other animal in EB-5 land. It takes significant amount of time and energy. And for those of you that are currently on an H-1B and thinking about a direct, you need to give it very, very long, hard thought, because your H-1B does not allow you to do constructive work or active work for another employer, right? And so doing a direct while you are on EB-5 or doing an EB-5 direct while you are on H-1B makes it all the more likely that you will inadvertently violate the terms of your status for H-1B. And that is a significant risk you need to be aware of. So if that's something you want to do, I'm happy to speak to you about it. I've helped enough people, but it's just something that you need to spend a lot of time planning for and doing it properly. The other issue that we are seeing right now is USCIS in their estimable brain capacity, which I cannot fathom for the life of me, have decided to reduce the amount of time you are now authorized for employment. It used to be until last month that my clients, when we filed adjustment of status, we would get a 3-year, if not 2-year EAD. We are now down to 18 months, right? So all the more reason for those of you that are thinking of doing a direct, all the more reason for you to think twice about it. Your EADs are now down to 18 months. So for those of you that are on H-1B that are thinking of filing for EB-5, my recommendation, and I'll say this upfront, I tend to practice more conservatively perhaps than a lot of the attorneys, but a lot of that is also because I am a first-generation immigrant. I don't want to take unnecessary risks for my clients, right? So I tend to practice more conservatively than others. What that means is effectively, I always tell my clients, to the extent that you can maintain your underlying status, whether that is an O, an H, an L, an F, whatever that may be, keep that underlying status active until and unless you have a green card through the EB-5 program, right? Now, if you are working, at an Amazon or one of the tech companies, AI companies, and there's a job separation, that's a different issue. I think you can then comfortably start using your EAD instead of having, to face that 60-day clock. But to the extent that you can, keep the underlying visa status active. And so if that is what you're doing, or that if that is not possible, rather, and now you're thinking of moving full-time to the adjustment of status mode and you're working on under the EAD, then you have to be aware that there is this possibility of job loss and job separation at 18 months, because USCIS does not allow you to file an EAD using premium, right? You can only file that regular processing. So just understand that is a risk right now that has just come up. Okay. Project selection issues, like you can see in bold, I have said immigration attorneys cannot recommend where you should invest. We can give you anecdotal evidence. We can do what I call restricted due diligence, right? So things like how many projects has the project successfully, regional center successfully completed? What are the metrics? How are you getting your money back? What is the experience of the people that are running this project and similar projects, right? A new project does not mean a bad project. Understand that, right? If somebody does not have prior investors, that doesn't necessarily mean you go running for the hills. It means you spend time trying to understand what is their experience and expertise with similar investments in the past. How many projects have they, what is their experience or expertise in real estate, if it's a real estate offering, right? You want to spend some time doing due diligence. Attorneys can give you information, but unless the attorney is a registered broker-dealer, they cannot tell you where to invest. The most they can say is, here are 3 options. The final decision is yours, and it needs to be your decision. Attorneys in regional center also cannot give you any guarantees. I've heard of some clients say, well, XYZ Regional Center told me that they're building a condominium complex, and if things go south, they can use the money that I gave them and that I can reinvest that into the condominium. Anybody telling you something like that, literally run in the opposite direction as fast as you possibly can. That is completely illegal. Okay, there is a lot of nonsense happening in EB-5 land, and you need to be careful about it. One of the things you want to understand also is the capital stack, right? So Who are the people involved in terms of the money? Where is the money coming from? Is there a senior loan? Is there a mezzanine loan? Where do the EB-5 investors sit, right? Because one of the things you want to always be conscious of is what happens if things go wrong. You obviously don't want things to go wrong, but you want to be prepared for what happens if they do. And so if you are third in line to get repaid because there's a senior loan and then there's a mezzanine loan, what that means is you're literally getting pennies on your dollar, right, for your investment, because the other investors or the other holders of the loan are going to get paid out. You're effectively going to get what's left. And so you want to find out, are you in senior position? Are you in secondary position? A lot of this depends on your personal risk appetite, right? Maybe you're somebody that, was smart enough to have bought billions of crypto and you don't care if you lose 800,000. So you may be perfectly fine, second or third position. But those are just questions for you to understand. Also understand that the law requires an EB-5 investor to have been credited with 10 full-time jobs for qualified US workers, okay? Qualified US workers per regulation are defined as US citizens, lawful permanent residents, and select asylees and refugees. So 10 jobs must be created. One of the questions I always ask projects is, what is your job cushion? You're required to create 10. How many above 10 are you creating per investor? The higher the cushion, the safer that project, right? So again, when you're looking at projects, a couple of things you want to keep in mind. All right. Documenting the source and path of funds. So I want to spend a little bit of time on this. Your EB-5 application can run into serious problems at 2 points in its lifetime. The first point is at the very beginning. Once you file your I-526E, IPO officers spend majority of the time looking at your source of funds. When and how did you earn that money, and have you provided enough documentary evidence to show how and when you earned that money? If you don't meet that documentary standard, it's possible that you would end up with, at best, a very difficult RFE, or at worst, a denial. Okay? So you want to be careful about how and when you're getting that, like what documents are you providing and how are you coming up with the money? The reason I talk about the 10 jobs being critical is because that is the second point at which you might lose your EB-5. If the project fails, God forbid, if they fail, but they created the 10 jobs per investor, it is possible for you to still get your green card. You may not get all of your money back, but you will still get your green card. But if the project does not get completed and they have not created the 10 jobs per investor, then you lose your green card and you lose the money, right? So again, when I say pay attention to the job cushion, there is a reason I say that. Now, with respect to the source and path of funds, USCIS holds EB-5 applicants to what's called the preponderance of the evidence standard, right? What that basically means is, does your story make sense? When you're telling me this is how you came up with the 800,000, the way I explain this to clients is, am I going to laugh when you try and explain it to me? If you're telling me you have 800,000 because your friends love you so much and you have 8 friends, each of whom gave you 100,000 each, and each of them have given you a letter, the first thing I'm going to do, I'm going to ask you for introductions to these friends, because believe me, I don't have 8 friends that are giving me 100,000 each. Okay, so again, when I say it has to pass the laugh test, that's what I mean. It has to be realistic. What's important is, how did you come up with the money, but also what's important is, how did the money get to the regional center? So for those of you that are thinking of transferring funds from outside of the country, for those of you that may be citizens of China, be very careful. For those of you that are citizens of India and are residents of India, be very careful. China has very, very strict currency restrictions. You cannot send more than, I think it's 25,000 renminbi per year, 250,000 renminbi per year. The regional centers are seeing right now, just as a whole, right? Regional centers in general, we're seeing a much higher rate of RFEs, specifically challenging path of funds for Chinese and Indian citizens. And that's because of 2 issues. Number one, both of these countries have very strict currency controls, like I said. China and India both, if you are sending money out of China, including Hong Kong or India, you are required to provide a specific code which says what is this money being used for. Historically, it was perfectly fine to say living expenses, for example, if you're a student, right? Or if you're here on an H-1B and your parents were gifting you money. Instead of saying it's for an EB-5 investment, they would just say living expenses in the US. Or if you were a student, they'd say education expenses. But that doesn't match what the RBI, the Reserve Bank of India, wants you to say, because it needs to say it's going for an investment because that's what it's going for. But the Reserve Bank of India doesn't allow you to send money outside of India for investments, particularly speculative real estate investments, especially if you got that money as a loan inside India. And so that prohibition is from the Indian government, which says an Indian citizen resident of India cannot take India-sourced loan funds outside of India to invest in a speculative real estate investment. And that's because you can thank the Vijay Mallya's and the Nirav Modis of the world. Okay? But you need to be aware of that. Again, how you got your money, where you got your money, when you got your money. How did that money get into the United States? And how did it go from your bank account to the regional center account? So, two things here that are now a problem for the IPO, which is the Investor Program Office. Historically has not been a problem, but we've started seeing significant RFEs if there is a loan model. So if you are taking a loan from the regional center itself, that is an issue for IPO. And what IPO is saying is basically you are a real estate developer, right? You were not organized, you have not been licensed to give loans, which is basically either a loan agency or a bank. You cannot be a real estate developer who is also dual functioning as a bank, right? And so any regional centers that are giving loans to investors to invest in their own projects, much higher chance of an RFE. Similar for SDIRA loans. So the self-directed IRAs. SDIRA was not even an option for EB-5 until maybe 2 years ago, right? And then there was a lot of publicity, I'm going to say, about how SDIRA was an option. USCIS is pushing back on that massively. The third thing that we're seeing is significant RFEs for people that are doing a installment plan. Installment plans are fine. There's no problems with installment plans if you can make sure to show that the full 800,000 has been invested within about 8 months of the date that you submit your application. Again, going back to the earlier slide, I said it takes officers at IPO somewhere between, let's say, 8 to 10 months on average, right, to get to your file and to start reviewing it. And if they get to that file and review it and they see you've only invested 500,000, whereas you were supposed to invest 800, they have well within their rights to issue a notice of intent to deny. And what they are doing increasingly when they issue notice of intent to deny is saying you have 45 days to pay up full. Otherwise, this is going to get denied, right? So if you are going to do an installment plan, at least again, this is for my clients, this is what I tell my clients, work with your regional center to try and have that installment plan schedule done within 6 to 7 months from the data filing, so that you can avoid a significant RFE and certainly so that you can avoid a notice of intent to deny. All right, so back to the source of funds because it is crucial. USCIS, like I said, spends a significant amount of time now. So for those of you that, that may have done your due diligence and that may be looking at projects, one of the things you will hear projects talk about and try to distinguish themselves from other projects is to say, we have a 956F approved, right? I need you to understand as investors, the 956F approved does not mean necessarily that the project is splendid and perfect and it's not going to have any issues. What that means is the IPO and USCIS have already reviewed the project and the project meets all legal requirements. And so IPO officers don't have to spend time when they receive your application going through the project documents because they've already done that, right? They just get to spend more time focusing solely on your source of funds documents and on you as an individual applicant. Do you have a significantly difficult immigration history, for example? Do you have any crimes that may disqualify you from being eligible for adjustment of status, right? It is possible to apply for EB-5, but then be denied adjustment of status. And so then you're left having to leave the country and apply for consular processing. That may happen if you've had a violation of status, if you have any criminal record in the past, right? So, like right now, the other thing that's happening outside of EB-5 land is Department of State is sending provisional revocation notices to people that are on H-1B and F-1s. And this may be because you didn't take enough credits. You know, when you were an F1 student, you were required to have 12, maybe you fell down to 9. Immigration has figured that out now, late in the game, but now they are sending you a provisional revocation notice. And so let's say you're one of those people, right? You may apply for I-526 with adjustment of status. But if you're not able to do the adjustment of status, then you would have to do the consular processing. The reason all of that is important in terms of the source of funds is because this is where the document, where you essentially tell them your life story. Right now, some attorneys will outsource this to others. I tend to write these myself because I feel it gives me maximum control over telling my client's story, right? And so this, for me at least, typically has an introduction to the client, your immigration status, when did you come to the US, what immigration statuses have you held, right? This person came in on an F1, they were on an F1 till this year, now they're on an H1B, this is where they earn their money, it went into this account, right? Like they have this much in brokerage because they have presumably ESOPs, you have, restricted stock options that you have now utilized, or you have CDs that you put 5 years ago that you are now accessing. Whatever your story is about when and how you came into that money or collected that money, where was that money accumulated? Your bank account needs to show, if you're saying, for example, I have sent 400,000 to the regional center as part of the installment plan that I have. What immigration expects to see is a bank account showing 400,000 sitting in that account at some point, right? So the source of funds report is where all of that information sits. It is a crucial document, and attorneys can only do a good job of this if you provide the accurate documents that the attorneys need. Okay, so moving into 2026, what are some of the issues that we're seeing? There is a very real possibility of retrogression. The service as of now has more applications than we have visas available for. The reason we have not seen a retrogression, and everybody was expecting one earlier, the reason we have not seen a retrogression, and we likely will not see a retrogression, I'm hopeful until maybe the spring, is because the consulates, particularly Mission India, the US consular system in India, Mission India right now is absolutely slammed with applications that they have had to postpone. So if you are, one of those with friends or family that is stuck in India because they had appointments in December 2025, and I have clients with appointments in December 2025 that have now been rescheduled to August of 2026. What that means is visas are not being issued. The way that the system works, the immigration system works, is every country has an allocation of 7% of the total available visas, right? You cannot count allocations based on the number of applications pending. Retrogression will only come in once more visas have been allocated than there are visas available. So the reason we haven't seen the retrogression is because there are EB-5 applicants born in India, even though they may be living in, Germany or UAE or wherever, born in India, that have not received a visa yet. UAE, for example, I have multiple clients in UAE. UAE, for example, it's taking almost 16 months after the visa, the I-526 has been approved, in order for that person to go into the consulate and receive an appointment, in order for them to get the visa. Right. So the only reason we haven't seen a retrogression is because of what's happening at the consulates, but it is possible that there will be a retrogression. Retrogression impacts those of you that are in the US on H-1B because you cannot apply for adjustment of status if the visa bulletin is not current. In order to apply for adjustment of status, number one, you have to be in status and a visa has to be immediately available, right? So up till the point where we hit retrogression, you can apply for I-526E or EB-5 along with adjustment of status. If there is a retrogression later in the year, at least you've already applied for adjustment of status, which means you would still get your EAD and your travel permit. It may just be a bit of a wait before you actually get the green card, right? But there is a possibility of retrogression. And retrogression, if it happens, would happen for both rural and HUA. The only one that I think may be shielded somewhat from immediate retrogression is infrastructure. But again, infrastructure only has 2%, right? So as of July 2024, I haven't been able to find statistics for after that, but as of July 2024, there were 1,341 petitions pending at USCIS or at the consulates from India. That's 20%. So again, remember, like I said, there's only a 7% allocation. Some of these people may decide they don't want to wait after all, right? People may have left. I know I have clients, we're filing for withdrawals because we were able to get EB-1s for some of them. Some of them got married to US citizens, so they don't need it. They don't need to go through the EB-5 process. So there may be some that fall off because of attrition. But just based on the number of applications filed with USCIS, there is a hidden backlog, right? So for those of you that read various blogs, like Susan Aziki talks about a 10-year wait timeline. I think she's using the number of applications, but not every application is actually going to get to the finish line. But understand that there is a very real possibility of a retrogression sometime in 2026. Why is that important? September 30th, 2026 is a really, really crucial timeline for those of you that are still considering EB-5 and wondering whether you want to get in on it. So one of the things that we fought for, when I say we, I mean those of us that, again, have been in EB-5 land for longer than we should have had the good sense to be honestly at this point. But the grandfathering clause in the RIA is pretty significant, right? The Reform and Integrity Act has significant protections for investors. For the first time, for example, EB-5 regional center projects have to go through significant background checks. All the project owners, leaders, people involved with the project have to go through significant background checks. And that was done to reduce the number of fraudulent actors and fraudulent EB-5 investments. Again, if you know anything about EB-5 and you've done your research, you know that there are almost 2,500 Chinese investors that have lost money over the years to fraudulent bad actors in EB-5. And so one of the reforms that we fought for under protect the investors. What the grandfathering clause basically says is if you have submitted your EB-5 application by September 30th, 2026, the regional center program, the pilot version of the EB-5 program, is due to sunset September 30th, 2027, right? And so what that means is October 1, 2027, we may no longer have an EB-5 program. The EB-5 program might actually become the Trump Gold Card, Platinum Card, Double Platinum Emerald, call it what you will, program. Or more likely than not, the 800,000 is going to go up to 1 million, right? So again, like I keep saying, I've been in this longer than sense dictated. The last time around, when we were at 500,000, this was supposed to go up to 900,000, right? There was a significant battle to bring it down to 800. So it is possible that come October 2026, USCIS is going to decide we really need this to be at 1 million, because that is more on par with what some of the other European countries are demanding on investor projects, right? It's along the same lines, let's say. And so it's possible that they decide, okay, now you have to pay $1 million. So the reason you want to get your applications filed well before September 2026 is because of the protections that you get under the grandfathering clause. What the grandfathering clause basically says is if you file before September 30th, 2026, if the program goes away, does not matter, your application still gets adjudicated. If they decide Trump, gold, platinum, whatever is taking its place, doesn't matter, you are still protected under the grandfathering clause. If they decide it now goes up from 800 to a million, doesn't affect you, you don't need to top up, right? You're good at 800,000. Let's say you can't get your funds in place, you can't do any of it. And if you are going to file this now, one of the things, again, like I said, I tend to practice more conservatively, but it is to the benefit of my clients. One of the things that I am at least advising regional centers I work with and my clients, any installment payment plans that you may be entering into right now, make sure that you are fully vested, as in you have invested that 800,000 before September 30th, 2026. Because we don't know how USCIS is going to treat you. As an investor, if you've invested 400,000 August 2026, we don't know if they're going to say, okay, but you hadn't fully invested. So the grandfathering provisions don't apply to you. You were in the process of investing, right? So for anybody investing now, do so with the intention of being able to be fully vested on or before September 30th, 2026. All right. I do want to talk about the Trump Gold Platinum cards because particularly for those of you that may be on H-1Bs, there are significant differences between EB-5 and this, right? So as of now, these are two completely different programs on completely different tracks. It is nowhere near the same as an EB-5. It was a proposal. Congress has not enacted any law yet, but it has been created by an act of administrative fiat, meaning that the president has created the Trump Gold Card as a administrative act, right? Which means this is a program that is good for as long as he is president. If there is a change in government, the new administration has every right to scrap the program. And we don't know entirely what happens to people that may have invested and may have put in the $1 million or the 2 million if it's a corporation. There's no way of knowing what happens to them if they had already invested. So as of now, it is $1 million for an individual with a $15,000 filing fee. It is a gift to the US government. It is not an investment. You get 0% of it back. As far as we know for right now, and we know very little, we don't know if there is a job creation requirement. It doesn't appear that there is. We do know that it is going to sit in EB-1 and EB-2. So for those of you that are from India, there is already a backlog of about 3 years minimum on EB-1. EB-2 is the same as your perm EB-2, by the way. The only difference with this is it's likely to go as a national interest waiver application. But you would still be in the same perm EB-2 line, which for India is anybody's guess, but somewhere between 15 to 30 years by last estimate before you get a green card. We're not entirely sure where the money is going, right? So we know it's going to the Treasury. We know it's going as a gift to the Treasury. You're not getting any part of it back because it is a gift. But we also don't know, for example, an EB-1 requires by regulation the applicant to show a minimum of 3 criteria, right? I also file EB-1s and EB-2s and NIWs. Or I don't do perms, I do EB-1s and NIWs. But we're getting RFPs for people with 5 patents saying, we don't think you have enough, right? So I don't know what the criteria is for gold card or platinum card in order to fill those minimum 3 criteria for EB-1, similar for NIW. So, I mean, if you really want to do it and you have no other option, I suppose this is an option, but just understand that it leaves you at a much more perilous position in terms of your legal status, because again, it is an administrative fiat act, meaning that it can go away tomorrow. We have no idea what happens come 2028. But more than that, if you are born in India and if you are an Indian-born person, you're facing a backlog already because there is already a backlog for EB-1, EB-2, right? EB-5, at least for now, there is no backlog. You can apply for adjustment of status. on this one, you can't even apply for adjustment of status because the visa bulletin is not current. Okay. All right. Then the entire program, the RIA, the EB-5 pilot program, which is the regional center program, is currently scheduled to go away in 2027. The last time this happened was in 2018 when the program was not reauthorized for 2 years. So for that 2 year period, you could only do the direct EB-5, but there was no regional center model for 2 years back in 2018. So as I said, when we get to 2026 and we start negotiating with IPO and with Congress, it may be that the program stays the same. Far more likely is that you will be facing a program that has a much higher investment threshold, particularly given where the US economy is right now. They need the cash infusion, to be honest. And it might be that, a program that looks more like the Trump card program or the entire Trump card program becomes the EB-5 program. We don't know yet. So if you are seriously thinking of EB-5, your safest best bet is to get your applications filed before September end of 2026, and also to try and do everything that you can to make sure that you are fully vested before the end of September 2026, just so you have maximum protections. All right. So again, you've got my email, my phone number. Feel free to send me an email if you have any questions. Sorry, I know I covered a lot. It was a lot to dump on everybody, but this is really important because it's in where we are in EB-5 world right now is really crucial. And I wanted to make sure you had that information looking ahead so you can plan accordingly for yourselves and your families. But I will stick around in case there are any questions.
Oh, thank you. I actually have a question that, if you don't mind, I'll read it to you.
Yeah.
It's from an anonymous attendee. If there is a layoff, then is relying on EAD to maintain status and then going to H-1B when we have a job. Is that okay?
Yes. Yeah. So let's say you apply for EB-5 and you're working based on the EAD, and then at some point you want to get back onto H-1B. That is an option, but you're likely going to need to consular process, which again, given everything that's happening in Mission India right now with visa appointments, that's something you definitely want to plan way ahead for.
And then I just have, I think we talk so much about retrogression, but what people don't seem, at least when I talk to potential investors, a lot of times what they don't seem to understand is that when retrogression happens, even if they're in, the states of the time on an F1 or an H-1B, they have no choice but to go through consular processing. Is that correct? If a retrogression happens and they have not yet filed and they're kind of hold off, at that point they no longer have the option of simultaneous filing, right?
You cannot file simultaneously, right? So that's what I mean. If there is a retrogression that is reflected, so for example, as of now, there is no retrogression reflected in the January visa bulletin, which means up through the end of January, you can file your I-526Es along with an application for adjustment of status. But if the February visa bulletin, which should be out by on or about January 20th, shows a retrogression in February, then you can only file the I-526E. You wouldn't even be able to file an adjustment of status application.
It's a follow-up. Consular process might also involve the $100,000 fee if H1 is out of state. I'm sorry, out of status. If H1B is out of status.
So, okay, I think we're getting wires crossed here. The 100,000 fee is for H1B, not for consular processing for EB-5 applications. So I want to make sure folks aren't getting confused, right? That 100,000 fee is if you are re-entering or if you are entering the United States on a new H1B that was filed for you after September 11th, I think it was, of 2025. But if you have to go back and consular process and come back in on an EB-5, an EB-5 is basically a temporary green card. There is no 100,000 fee that applies to an EB-5.
Right. So I think they're just kind of getting a little bit mixed up. And then one last question. It says, Well, there are more questions coming in now as I said that. If an I-526E is filed before September 30th, 2026 and fully funded as a fully funded investment, assuming there is an RFE that comes in February of 2027 for this petition, will an RFE response filed by the investor be processed?
Yes. So again, one of the crucial things about the grandfathering is as long as your initial application is submitted, and USCIS follows what we refer to as the approvable when filed, right? So if the case was otherwise approvable at the time that it was filed, then your case will be processed. And if that means an RFE is issued and then you have an opportunity to respond to the RFE, that is what is going to happen.
And then this is, the last one for now. So it says, at what point is it appropriate to pursue a writ of mandamus for a delayed I-526E HUA petition?
Depends on your definition of delay. I'll give you the very lawyer answer. It depends on your definition of delay. So again, I file mandamuses all the time. It depends on the particular project. At what point? So one of the things I think you want to look at, understand that a writ of mandamus is not a required step of the EB-5 process, right? I want to make sure I say that because it sounds like for some people, I don't know if this is coming from regional centers or if this is coming from, ChatGPT or what have you, but some people seem to think that a writ of mandamus is a part of the EB-5 process. It's not. Right? A lot of my clients don't go through, a lot of my applications don't go through a writ of mandamus. But if you applied for an I-526E, let's say 2024, right? January 2024, we're now heading into 2026. You don't have a decision, but people that filed alongside you or after you already have an approval, then I think it is perfectly ripe, which is what federal court calls it, in order to file a writ of mandamus and say, I am being unfairly disadvantaged because others that filed along the same time as me already have a decision, whereas I don't. The other thing that you want to look at also is how long has your application been pending, right? There is no definite timeline that triggers a writ of mandamus. Generally, if USCIS is saying average processing time is 6 to 8 months and your application has been pending, let's say 10 months, you might want to give it a one or 2 months more and then file the writ at 12 months. But there is no hard and fast rule that X number of months means you can go ahead and file for a writ of mandamus. It really depends on the project and the investors and where you are in terms of the other investors.
And then it's another question just came in. Given retrogression is a strong possibility, do we have any estimate for how long back will it go?
No, and that is a guess.
That's a guess. That's so.
Yeah.
And I personally just had, you were speaking about HUA timelines and rural timelines, and you were saying that maybe up until the end of the summer, you were seeing a more significant difference in education, like, kind of EAD timelines. So, and you were saying that for now, right now, what you're seeing is for rural about 6 to 9 months, and then for HUA about 8 to 12 months. So
majority of my rural applications, we have approvals on almost all of my rurals at the 10-month mark.
At the
right?
10
So we're somewhere between 6 to 10 on average. My HUAs are probably somewhere in the 10 to 12. I do have some HUAs that have come in at about 8 months, but for the most part, we seem to be at about the 10 to 12 month mark.
So at this point, you would say it's kind of not a
They're
very
about average.
drastic.
There's really not that much of a difference. Right now, again, you'll hear, various people talk about, oh, but if there's a retrogression, rural is going to go first, and then you'll have another group that says, well, HUA is going to go first. That's all a guess, right? So
Speculation.
I want people to understand that that is just speculation.
But I think a
All we are doing,
lot of these investor concerns are coming from that that article which Susan has written, where people are concerned, oh, if I invest in HUA, then looks like it's like 8 to 10 years. or wait
But
time?
again, like I said, I have immense respect for Susan and the work that she does, but she doesn't run the visa bulletin, right? I mean, what she's doing is basically basing her predictions on the number of applications that have been filed and that are pending at USCIS and at consulates compared with the number of visas we have available every year. And so I will say this again, as somebody that files EB-5s, I have some clients who have decided it's not worth it, that got their EB-1s, and so they no longer need their EB-5s, got married to US citizens, have decided to pack up and move to Canada or Greece or wherever.
Mhm.
Right. So there are a lot of unknowns. I mean, I'll say this, like I remember having this conversation with Charlie a couple of years ago. So Charlie Oppenheim used to run the visa bulletin. And the last time we had this discussion about retrogression, Charlie's calculations were something like 10 years.
Mhm.
And when we said why, his underlying estimate was that most Indian investors would have a family size of 5, right? So he was calculating for 3 children.
Right.
Most of the people that are filing for EB-5, at least for me, are folks that are young professionals on H-1Bs, where it's 2,
Mhm.
right? But that leaves you a 3 visas per family availability
Right.
that was overestimated.
Right.
So this is not to downplay the possibility of a retrogression. I just don't know, honestly, if I believe the 10-year projections.
Right. Right.
Right, means
And then I have,
also means even if you look at that two things, projection is one thing, and actually we see that the real results. Like, means I don't see as many results as you do see, but I keep on hearing people get HA approvals or rural approvals in 6 to 10 months. So that tells me, okay, even if there is so many backlog in the number of applications available or filed with the USCIS, approvals are still happening. It's not like everybody's have to wait for 10 years to get their green card.
Well, approvals are happening, yes, but again, you are counted based on your country of birth, not your
Right,
country of citizenship,
right.
right? So if you are filing for EB-5 and you were born in, Latvia or Nepal, you're not facing a retrogression.
Mm-hmm.
And so you may very well be able to file for adjustment of status along with your I-526 or be able to get consular processing if you are outside of the country within 6 or 7 months. But if you are an Indian national who is filing in 2025 and there is a retrogression, let's say going back to 2024, if and when a retrogression does hit, if you've already submitted your application with concurrent filing, then you already have your work permit and your EAD that is being processed and will continue to be processed even if there is a retrogression.
Yeah.
It
Mhm.
just means you're not getting your green card.
Right. And then I have a question. Is the 7% per country limitation calculated within the rural HUA set asides or at the broader EB-5 annual 10,000 visa cap?
So the 7% is at the 10,000 cap, right? And then within that 7%, each country can only get 7%.
Right. So do we have any? I think we've answered pretty much all of the questions that have come up. And I guess quickly, we don't have much time, but I wanted to talk a little bit about our current project that we're offering. It is called Zen at Desert Sky, and I'm quickly going to a second. I'm quickly just going to. Can I just be honest? I am not good at this.
Prima, I don't think so. We have time to run the presentation. Maybe you can
Yeah.
just talk about it a little bit.
Yeah, sure, absolutely. So as we mentioned earlier, and as we have been talking, it is an HUA project offered at the $800,000 investment level. It's a very small, I would call it a little boutique project with very small, we're looking for about where we need at this point, we really don't really, maybe we have six slots left. And overall, it's a project that is in Phoenix. It is a built-to-rent project, real estate project, and at the end of the day, I think that when we look at EB-5, it's really, as somebody who's worked with so many investors, I, like Kripa, have also been in this EB-5 game for way longer than I should have been. And when I look at a project, I really tell every investor that, like, please understand the capital stack. I know that not every investor coming in works in finance, and sometimes it gets, a lot of capital stacks for projects could get extremely confusing. And the reason I love this project so much is because it's an extremely simple capital stack. Anyone can read through our PPM and kind of get what's happening. It's not a project that we're doing insane marketing for. There are no bells and whistles. It's just a really good, solid EB-5 project that, I really recommend that you take a look at. As we don't have that much time, I do want to say that if anyone is interested, I'd be more than happy to set up a meeting, go through our deck. And Bhuplesh, who's here on our Zoom with us, is the fund manager for the project. And for December and January, so for any investors that came in December, and now we're offering that throughout January as well. Kripa talked about the investor fees and admin fees and how high they can get. We're waiving the admin fee for the project, which is an $80,000 waive for all investors that came in December, as well as investors that come in January. Also, for investors that come in December and January, we are offering a 3% return on the project, which is, quite substantial once you kind of look through it. But if there's anyone at all, again, you can message us here. This entire Zoom, as I said before, it was completely educational. We are very, very happy to talk more about, just EB-5, the legalities and just investor protections, because at the end of the day, that you feel safe in your investment and you trust and you feel that you've made the right decision. And I think that comes with the more education and more you know about the project, more you know about the developer. And this particular developer, they've been developing in the Phoenix area for more than a decade, also nationally. But the sweet spot is the build to rent that they do in Phoenix. The location is amazing. I think it's adjacent to over hundreds of thousands of jobs that are, just kind of locally. There are AI chip factories. Phoenix has just so much industry. And again, I'm just trying to really just kind of give you everything in a nutshell. But if you would like to talk further, Bhuplesh or myself, we'd be very happy to have a private Zoom with you and kind of go through any questions that you might have. But then at this point, I just want to again thank Kripa so much for being here tonight. Always such a wealth of knowledge. If anyone wants to talk to Kripa, please get in touch with me. I'm more than happy to connect to you. And I hope everyone is enjoying this little time between, Christmas and New Year's. And thank you all for joining us. And from Zen EB-5, we will be doing another webinar next Monday. And so we will be kind of pushing that out soon. And anybody who'd like to come on, we'll talk a little bit more about the project on that one. So thank you all very much. Thank you again, Kripa. Thank you again, Bhuplesh. And we hope that everybody learned something tonight. And I'm sure you did. I'm sure you did. Yeah. Thank you.
Thank you very much for having me, Bhuplesh and Rima. Again, if anybody has questions, feel free to connect with me via Rima. I'm more than happy to answer questions. I'm sure there are several. I'm more than happy to answer any questions you may have. But have a wonderful New Year as well to all of you. Thank you very much.
Thank you.
Bye-bye.